Michael Leaves is here with the Day in Sports, and the concussion issue, we touched on it yesterday, has really hit the NHL now.
Yeah, now the question is, how big will it become? Yeah. You know, 3 months after the NFL agreed to pay at least $765 million to former players over concussion-related health problems, 10 former hockey players, including former All-Star forward Gary Lehman, have filed a similar lawsuit against the National Hockey League for not doing enough to protect players from concussions. Now, the suit contends that the NHL knew or should have known about scientific evidence that players who sustain repeated head injuries are greater at risk for illnesses and disabilities both during their hockey careers and later in life. That even after the NHL created a concussion program to study brain injuries affecting the NHL players in 1997, the league took no action to reduce the number and severity of concussions during a study period from 1997 to 2004, and that the league didn't do anything to protect players from unnecessary harm until 2010, when it made it a penalty to target a player's head. Now, after this lawsuit was filed yesterday in Washington, D.C. federal court, the NHL Deputy Commissioner Bill Daley released the following statement, quote, "While the subject matter is very serious, we are completely satisfied with the responsible manner in which the league and the Players Association have managed player safety over time, including with respect to head injuries and concussions. We intend to defend the case vigorously and have no further comment at this time," end quote. Joining me now to sort this whole legal matter out is Al Jazeera legal contributor Jami Floyd. Now, Jami, if I remember anything from my law classes in college, I know that precedent matters. So, with the settlement of the concussion-related lawsuit between the NFL and its former players, how will that have any bearing on this lawsuit against the National Hockey League?
Well, you stole my thunder because I wanted to use that word precedent. You used it first. We have that word precedent in law, and there is something called precedent, but there isn't one here because precedent really refers to those precedents set down by courts like the U.S. Supreme Court, and we don't have that. But you're exactly right, Michael, that this is a piggybacking off of that previous NFL settlement. The NHL players see what happened with the NFL brethren, and they're thinking, well, if they got a big settlement, maybe we can too. Of course, football is much bigger in the United States than is hockey, multi-billion-dollar sport versus a multi-million-dollar sport for Americans. But the potential here is bifold. They could also sue, Michael, in Canada. So I think we've got a lot to look forward to in this lawsuit and possibly another big settlement.
Well, what is the burden of proof in a lawsuit such as this one?
Well, you know, when we follow cases, we most often think about the presumption of innocence and proof beyond a reasonable doubt. And Michael, you remember this from law school too. That is a very, very heavy burden. But that's not what we're talking about in civil cases like this one. This is a much easier burden for the plaintiffs. They just have to tip the scale a little bit to show that the evidence is in their favor, that the NHL knew or should have known that they were going to suffer this kind of severe injury.
Well, Jami, you can make the argument that hockey is actually more dangerous than football. It's played on ice, the rink is surrounded by wood, the puck is really hard, and on top of that, one of the most popular aspects of the game is fighting, and it's not discouraged, it's actually rather encouraged. How might that aspect of the game play into a concussion-related lawsuit?
Well, they can argue, I think, actually in their defense, the NHL can, the league can, that this works in their favor, that players themselves knew or should have known that it was a dangerous sport. And then there's a third party in all of this, Michael, and that is the Players Association, the people who negotiate the contracts. The fact that this is a negotiated sport, maybe we shouldn't even be in a court of law. Maybe we should go to arbitration. And that these folks enter into this knowingly. So there's a lot of complicated stuff that has to happen before we even get to a trial. In fact, are these people even a class, these players, all uniquely situated as one to go forward as a group? A judge has to determine that they can do that.
So a lot of questions to be answered, and we'll see how long it takes for those to be answered. Jami Floyd, legal contributor here at Al Jazeera, thanks so much.